I'm going now to have a little look about what will happen, or to give you some outlines of what's likely to happen if you do get included in a claim. Before I do that, though, these legal issues I've talked about, they apply whether it's a claim in the courts or a claim in the tribunal. Some of the things I'm going to be looking at now, there is a significant difference between how claims progress in the tribunal and how they progress in the courts. But there's probably three stages in which a designer may be informed, or you may get notice that you might be in the unfortunate position of being named as a party in a leaky home claim. The first or the earliest you might be notified is if the claimants decide that they're going to do the remedial work prior to filing a claim with the tribunal. They should give notice to all the parties who they believe they will be naming in the tribunal prior to doing the remedial work, and giving those parties an opportunity to go and inspect the dwelling before the remedial work starts, and even to get an expert to go and look at it when the cladding's off and in the process of the remedial work. That's likely to be by way of a letter saying, you know, we've been found to have an eligible claim and we're going to proceed with the remedial work, and then bring a claim against you. If that happens, again with the other things I'm talking about, don't do the ostrich act, bury your head in the sand and hope it will all go away. Take the opportunity of going to look at the dwelling before the remedial work starts, because one of the things you want to look at is whether in fact the design work you did was followed. You may also want to look at whether you in fact did the design work, because we have had a number of parties who have been named in claims because their name happens to appear on some documentation in the council file or on lists of contractors, and they didn't actually do the work. I had one claim that went to mediation the other day, and foolishly the party didn't go and have a look at the property till after mediation. He had put an offer on the table at mediation. It hadn't been accepted, but when he went back to the property he realised he hadn't done the work. This was a roofer, and he said it was one of 3 units, and he had done the work on the back unit, but he said the product on the front unit, which was the subject of the claim, had my competitor's product on it, so I didn't do the roofing work. If he had gone to look at the house as soon as he had been named as a party, he would have been removed at that stage without having gone through all the mediation and potentially paying out to have a settlement if the claimants had accepted his offer. Because that particular claim, even though it didn't settle at mediation, settled a week before the adjudication hearing, and so he very nearly got to having to pay out. So you know so if you are given that opportunity, go and do it. Have a look at the home. If you're not provided with a copy of the assessor's report, ask the claimants for a copy of the assessor's report so that you can look at the report to see where the assessor's opinion is that the defects are, and to see whether they do relate to the design work, and also go back to the property to see whether the design was followed in relation to or the technical literature was followed in relation to those key defects which are pointed out in the assessor's report. The other time designers receive notice is if they're named as parties when the claim is filed with the tribunal. You will at that stage get a copy of the application being made against you. You'll get a copy of the assessor's report, the other documentation that is filed by the claimants, together with notice of when the preliminary conference is going to be, which is likely to be in 2 or 3 weeks from when you get that letter. Quite often the documentation is on a CD which is sent out with the application form. Open the CD, download the documents and have a look at them, and if you can't open it, contact the case manager whose name will be on the bottom of the letter and ask them to send you another one. I've often had preliminary conferences where respondents have come along and said, "Oh, I haven't got any of the documents you're referring to. I haven't seen the assessor's report. I haven't got this, I haven't got that." I said, "Have you opened the CD that got sent to you?" "Oh no," they said. I said, "I think you'll find it on there." And it's quite important to look at that information and to start doing something quite quickly, as you'll see in a minute. The third time you're likely to get notice is if you're joined to a claim, or if someone applies to join you to a claim after the claim has been filed. and that will be partway through the adjudication process. Sometimes applications to join parties are put on notice. So if you get notice that someone is joining you to a tribunal claim, you should also receive notice of what you're wanting to do if you want to oppose it. As the designer, I suggest you think very seriously of opposing it. It is much easier to oppose an application to join you to a claim than it is to apply to be removed. Some parties think, oh, I'll just wait and I'll apply to be removed once I'm joined. There are quite different legal tests. To join a party, the person who is applying to join them needs to provide an evidential basis for the joinder. So if they need to provide some evidence that there were deficiencies in the design work, for example, that has led to the dwelling leaking. Once you are a party, to get removed, they don't have to provide an evidential basis to prove their claim. All they have to do is argue that there was an arguable case. So it's much easier to oppose a joinder application than to apply to be removed. So oppose it if you think you have grounds for doing it. Again, look at the assessor's report, look at what the claimant or the person who's applied to join you is alleging against you. Look to see whether there is any evidence that links the design work to the defects in the dwelling, or whether it's construction or issues or failure to provide technical, follow the technical literature. Now this is an outline of the tribunal process. As I said before, we have I've got joinders and removals here, but they usually come in here. So if you're named as a party, you'll get served with a claim. You'll get told of the date of the preliminary conference. If the property's in the South Island, that's likely to be a telephone conference. So you'll be given the details of how to phone in to join the conference. And you're also, between when you get that notice and the preliminary conference, are likely to be sent out an agenda of the things that are likely to be discussed at that conference. Now, at the conference, all parties who are named in the claim are required to attend. Well, we can't actually force people to do it, but we do ask them to attend, even if they've got legal counsel or a representative. We want them to come in person, because at that first conference, we have quite an in-depth discussion about how this house was built, who built it, who did what. The sort of questions that will be asked of designers is, you know, did you do the design work up to building consent stage only? And then if we look at and can't see what in the design work was an issue, we might ask the claimants as to what specifically that they're alleging against the designer, whether further particulars are required. And so if you've got questions to be asked about the claim that's being made against you, they can be raised at the preliminary conference. Or if you think that there are other parties who that you've been wrongly named, or there are other parties who should more appropriately be included, those issues can be raised. And at the conference, a timetable is set for dealing with joinders and removals, and I'll have a little bit, a brief look in a minute about applying to be removed from a claim. A timetable set for filing a response. Sometimes at that first conference we also talk about mediation. I might set a timetable for the whole claim. At other times there'll be another telephone conference scheduled for a few weeks' time. So the Act provides some very strict timeframes. We've got here, the Act actually provides that you've got 25 days to respond to a claim, or 25 working days from when you get served with it. We quite often extend that period because it's quite often unrealistic for varying reasons. The Act also provides that there's then a 25-day period for mediation and a 35 working day period for then having a hearing if there's no settlement. That's all very fast, and some of those timeframes can be extended, particularly if the larger claims. The average, if you look at average, the average quantum or value that's been claimed in the tribunal is probably currently somewhere around the 300,000, but we have claims from 15,000 through to, I think our largest claim at the moment is 15 million. So clearly, if it's a $15 million claim, expecting people to be able to respond or to do anything in 25 working days is somewhat unrealistic. Particularly in that claim, I think it's got 39 respondents and 91 claimants. We've just getting all the documentation together has taken about 6 months for the claimants to get all their documents together. So we set a timetable for all those things, but it can be pretty fast. And some of the time frames we can only extend with consent of all the parties. So, and even that 6-month time frame from filing to resolution doesn't allow a lot of time to do things, particularly if you want to get your own expert to look at the property or something like that for larger claims. So I came across this this Dilbert cartoon, and I thought, well, if we did comply with the time frames as suggested in the Act, we'd often be so blurry from moving so fast. So just some differences between the courts and tribunal. As I've said, it's much quicker. The other thing is the role of the assessor's report and the role of the assessor. All claimants have to file the assessor's report whether they're relying on it or not. And the assessor then becomes an expert to assist the tribunal. The assessor is not the claimant's expert. They are an independent expert. They can't be directed by the claimant. They can't be engaged by the claimant. The assessor will generally attends both mediation and adjudication. Clearly, any party can ask that the assessor be at mediation or adjudication. So if as a designer you look at the assessor's report and you think, well, this is pretty good, the assessor doesn't put any liability on me. They're suggesting it's construction defects and not design defects that have caused this problem. They don't suggest that the designer should be named. You can rely on the assessor's report as part of your defence, and with the knowledge that if the claimants don't want the assessor to be at mediation, you can request them to be, and they're likely to be at both the mediation and the adjudication. And so if the assessor's evidence is something that is favourable to you, that is, they'll be there giving their evidence or talking to their report at mediation, giving evidence in an adjudication hearing at no cost to you. So if the assessor's report has no liability, the claimants or the party seeking to join the designer is going to have to provide some other expert evidence to suggest that there are design defects. And that will also, that information should also be served on you at the time you're joined or the application is made to join you to the claim.
If the assessor's professional, presumably they're being paid for their time.
They're paid by the Department of Building and Housing. So yes, they don't do it for free. So it's a government. It's part of the government assistance to resolve the claims. The management of claims in the tribunal is different. When it first gets filed with the tribunal, I assign an adjudicator, who is sort of like a judge, who will deal with the claim from the beginning to the end in most cases, and one case manager gets assigned to the claim as well. So you're dealing with the same two people in terms of case management and in terms of the adjudication process. There are occasions when it may change if a conflict of interest arises or a staff member leaves, but the case manager, whose name and email and contact details will be on the first letter you get, should remain the main person throughout the claim that you can contact. If you've got any questions to ask in terms of processes or other issues, if there's documentation you haven't got, or you can't, things seem to be missing, or you can't open your disks, or anything like that, you can phone or email the case manager, who's there to assist all parties in terms of the progression of the claim. And the case manager and the adjudicator work together to try and progress the claim through in a fair and efficient manner. Sometimes fairly and efficiently aren't sort of mutually compatible. The tribunal also has an investigative role. The courts primarily make a decision based on the information that's presented to them by the parties, and so if the party doesn't provide the information to prove their claim or defence, then they're unlikely to be successful. The tribunal is more proactive in seeking information, so if there's information we think is available that will help us address the issues that need to be decided in the claim that parties aren't providing, we will ask them to provide it. One of the ongoing battles I have with some claimant representatives is that they're very reluctant to provide their experts' reports that they're basing their claim on, and they seem to think that they don't need to provide it, that they just need to provide a whole lot of pleadings or allegations. And I keep saying, no, the other parties need to see the technical basis of the claim to know how to respond to it. And so we often ask for that technical information to be provided if it's available. We can, and we're the adjudicators are much more involved in getting the information out, and if it goes to hearing and in asking questions and examining the information. We also, there's also a strong emphasis on mediation, and that's becoming more common in the courts as well. If there's not a mediation in a claim, we'll often have a judicial settlement conference which will be run by an adjudicator, but we try and see if the parties can work towards an agreement that they can live with rather than having one imposed upon them. But if there are a number of cases that go direct to hearing. We also tend to deal with expert evidence differently. If a claim is going to hearing and there are a number of experts involved, there might be a conference of experts prior to the hearing in which the experts get together without the lawyers and without the parties and try and reach an agreement on what the causes of the defects in the dwelling that caused it to leak and what's the appropriate scope of works to do the remedial work and what the cost may be. If you're a self-represented expert, I mean, if you're a designer, so you have expertise as a designer and you don't have your own expert, you may be able to attend the experts conference even though you are a party, but it becomes slightly problematic because an expert in a tribunal or court proceeding has to be independent and give their advice independently and not partially. And it becomes rather difficult if you're a party to also be independent. But we do at times allow parties to attend expert conferences if they are an expert in their own right and don't have their own experts, and so that's also something to consider. If the claim goes to adjudication, we usually hear all the experts on each issue together in a panel, rather than one after the other, or rather than traditionally in the courts you'd hear all the claimants' evidence first, so the claimants would give their evidence, then their expert would, then respondent one would give all their evidence and the expert would. We'll get all the experts together on one day, and in one of the claims I did, we actually had 3 panels of experts. The first panel was the experts in relation to the defects of the dwelling. They were then joined by, well, a couple of people left who were only giving evidence as to defects. Some others joined and they gave evidence as to the costs of the remedial work. And then I had a third panel, which were the design experts. The council and the claimants and the architect all had their own experts in relation to the design work, and they gave their evidence in a panel. And it made it much quicker in terms of the experts' involvement, which reduces the cost to all parties. And from my point of view as a person who needs to make the decision, it's much easier when you've got all the experts dealing with things issue by issue to work out where the differences lie and where the correct answer is than when you have one giving evidence one day and one in the afternoon and they haven't got the opportunity to discuss the issues together. So it's more informal, but I think more informative, and certainly the experts that have been involved in it now prefer it that way and keep saying, are we going to be giving evidence in a panel? Because they find it easier to be asking each other questions and then only to have the lawyers and the parties coming out at the end than to be bombarded with this series of questions from lawyers who are exposing their lack of knowledge of technical and building and design issues. We've talked a little bit about jointness and removals. Any party can apply to join another party. So often it's not the claimants who might apply to join a designer. Often it will be the council or one of the other respondents, maybe the developer or the builder. And as I said before, to join someone there needs to be a link between the work done by the party to be joined and the cause of the damage or the loss. Whilst claimants are free to name whatever party they wish to when they file their application with the tribunal, to join a party subsequently there needs to be an evidential link between, firstly, that party was involved and that the work that party has done has caused loss to the claimant. Now, with removals, we used to be a lot more generous at removing designers from claims, the tribunal was, than the courts, partly because of the legal tests that need to be applied. And we basically said to parties, if they wish to oppose a removal of any party, will you put up your evidence to show that there is potential liability, otherwise we'll remove them. The courts have said that the High Court unfortunately said that we can't do that anymore, that we have to apply the same tests as the High Court does to strike out. So basically to apply to be removed, you have to establish that the claim against you is so untenable or that it's unlikely to succeed. And if there are disputed facts, it must wait to a substantive hearing. So it is quite difficult to get out of a claim. But what needs to be done is to see whether there is any allegation or any evidence that links the work that you have done to the dwelling leaking. Yesterday, before I left to come down here, I had a claim where I'd asked the claimants to provide further details of the claim they were making against the designer and the council, because the council had only done building consent, it hadn't been involved in the inspections. And I got a memorandum from the claimant saying, well, we think it's already in the reports, we're not going to do it. So I looked through all the reports again, and there was nowhere in those reports that said anything about design issues causing the dwelling to leak. It was all deficiencies and workmanship issues. It was construction and workmanship issues. So I issued a memorandum saying, well, I have looked through all the expert reports and I can see no evidence, there's no allegations that it was the design work of this dwelling that's been causative of leaking. And even in the claimant's own statement and application, they didn't specify any design deficiencies. So I said to the claimants, you either give me some evidence that there is design work or the application for removal by the council and the designer is going to be successful. It remains to be seen whether they come up with any further information. I've given them a week to do that because they were supposed to have provided it to me 3 weeks ago. If not, there'll be a success. The parties, the designer and the council, are likely to succeed in being removed because there is nothing there to establish that there is any deficiencies in the design work which has caused the leaks. So they are the things you need to look at, and if there is no evidence and no allegations being made about that, then you can apply to be removed and you can refer to those issues and the fact that there is no allegations or evidence there. Not all joinders are put on notice, but quite frequently a joinder of a designer would be put on notice and you could oppose the joinder. That's not the case if you're named initially in the claim when it's filed with the tribunal. Through quirk of fate may depend on whether you're named initially or not. But the fact that, if a party applies to be removed and the tribunal concludes that they're not going to be removed because there is an arguable claim, there's certainly no decision made that that party will have any liability. All that's made is that there is an argument that can be raised. So it's not a determination of liability at all. So looking back, so all those issues are sort of, dealt with sort of in here. And we usually deal with the removal applications and the joinders before we require responses to the claim and before mediation. And if you decide not to apply to be removed, or you continue on or it's been unsuccessful, you then have to file a response to the claim, which just puts your side of things and whether you've got any defences that you're going to raise. So if you're going to be contesting the costings or saying that the claimants are contributing negligent because they didn't maintain the house and all those sorts of things, you need to list those in your response as well. So it's a summary of your case and of the defences that you'll be raising. And so you need to go through the main defects and outline whether you accept any responsibility for them or not. I'll just briefly deal with mediation. It is a voluntary process, so you can't be forced to attend a mediation. The things you have to decide is if you are going to go to mediation, you need to go prepared. I had a party the other day who went, well, it was a settlement conference, which is a similar type of thing. Their strategy was that they weren't going to do any preparation and that they were going to wait to get the decision, and if the decision was not favourable, they were going to then appeal and put all their work in then, and they'd get some legal advice at that stage. And I said to them, do you know how much it costs to appeal to the High Court? And they said no. And I said, well, it's $1,000 to file the claim, and then you have to pay security as to costs. And then I said, if you lose, you'll have costs awarded against you. They said, oh, and I said, and then you also have to prove that the adjudicator's decision is wrong. And he said to me, well, what happens if the claimants have lied? I said, it doesn't matter. The adjudicator's decision still has to be wrong. I said, it's a very risky strategy. He said, do you think I should go and get some advice? I said, yes, I think you should. But you need to go to mediation as well prepared as for a hearing, with a clear understanding, because it's only if you know the strengths and weaknesses of the case against you and the strengths and weaknesses of the defences you're raising, whether you know whether any settlement proposal that's been put together is a good one from your point of view or not. And so you also need to weigh up the likely outcome and costs of not participating in terms of mediation. And it not only the costs involved in going to a hearing and whether you're going to be legally represented or not, or even just the time off work to attend the hearing, what the likelihood of the hearing is going to be, and whether, and some parties decide, well, I don't think I've got any liability, but I'll put $15,000 into the pot to make it go away because it's cheaper for me to do that than to go to a hearing and face the risk of having a decision made against me. There are other designers who have said, I don't believe I've got any liability, I'm not going to participate in mediation. It can go to a hearing, and I'm confident I'll win at that, and I'm prepared to take that risk and pay whatever's involved to do that. That's the decision that each person needs to make individually. In mediation speak, they talk about whatners and batners, and they're the things that you need to look at in determining whether you should participate in a negotiated or mediated settlement. And so it's what's the worst alternative to a negotiated outcome and what's the best alternative to a negotiated outcome. If what you're being offered, the negotiated outcome, is as good or almost as good as the best alternative, then you might as well accept it. If it's worse than the worst alternative that you consider, then why would you? So you need to do a reasonable analysis of what's involved in deciding, firstly, whether to participate in mediation, and secondly, what sort of settlement proposal you're prepared to put forward. The other thing to remember with mediations is that partial settlements are becoming increasingly more frequent. What's happened in a recent claim of mine is a couple of the respondents thought that if all the other parties went along and settled it, then it wouldn't proceed against them, so they didn't do very much. And if it didn't settle, they would rely on the council's expert to contest liability and some other issues. What, however, happened is that the council settled with the claimants and the claimants proceeded against them only. So they were left defending a claim with no evidence to support their defence because the council was no longer there. And so there have also been some claims where the council has settled with the claimants and they have taken over the claimant's claim against the designers. So that is a risk of not participating in mediation. The other parties might settle and you may end up being the only party that is there to defend the claim. So there are things that you need to consider as well. It's happening more frequently, that these partial settlements. And what tends to happen, I know that there was one regular player, a waterproofer, whose strategy was not to turn up, and with the first 2 or 3 claims they settled and he didn't participate. It got up the noses of some of the other parties who then took over the claim and have proceeded to hearing against him. So it might work once or twice, but more often now partial settlements are reached and someone proceeds against the parties who aren't participating. It depends on the value of the claim, and it also, to be frank, depends on the council's assessment of whether they think the other parties are worth pursuing. So they usually try and get information about the financial worth of the other parties. So that sort of thing is done. And if it doesn't settle, it goes to an adjudication hearing. And the tribunal then makes orders against the parties, and so the decision's imposed upon you. If you don't turn up to a tribunal hearing, orders can still be made against you. In fact, the Act says that we can read an inference into people's non-attendance, and our inference usually is that they've got nothing to say to defend the claims, they must be liable. So it's a very risky strategy not to turn up to a hearing. Decisions of the tribunal can be enforced the same way as court orders, and there's a general right of appeal. I know time's gone, so just very briefly, do you need a lawyer, and it's sort of how long is a piece of string? 80% of all claims, the claimants are represented, and about 50% of respondents are represented, but that includes people who aren't participating. In almost every claim there will be lawyers involved. Having said that, there have been several claims where designers have successfully represented themselves in hearings. And of the claims that I have taken through to an adjudication hearing, the designers have probably been the most competent self-represented parties that I've had. It's an advantage for a respondent because as a designer, or as most respondents have technical knowledge, claimants have neither technical or legal knowledge. But what you do need to be aware is that there are sometimes some quite complex legal arguments raised, and legal advice is very helpful with, even if you are representing yourself, to get some legal advice around those issues. So just if you want further information, as I've said, the Tribunal does run seminars. We're going to be running another seminar in Christchurch because people have asked for it on the legal basis of claims and defences in the next 2 or 3 months. Information on that's available on the website. Whilst they're mainly claimants, and it can be slightly uncomfortable for a respondent to be sitting in a room of militant claimants, you are welcome to attend. I know one builder in the feedback said we should have separate seminars because the homeowners were sitting in the row in front of me and I didn't want to ask any questions. There's the Tribunal website. On that are copies of all the Tribunal determinations. There are also copies of key court decisions. There's copies of information on the legal basis of claims, and there's process information and a whole lot of other information on that. And as I said before, the Tribunal case manager is available to answer questions on any process issues. They can't answer questions on, is the claim against me going to be successful, or legal issues, or how much should I offer to pay at mediation to make this claim go away. It's not the sort of question they can answer, but they can give you all sorts of advice on the Tribunal processes if you're named in a claim. I think it's fair. A lot of the biggest area of ministerials is from people who are complaining about what transpires to be a mediation, but they say they were ordered to pay this amount of money. And so I think a lot of respondents leave a mediation feeling that they've been ordered to do something. In actual fact, it's supposed to be voluntary. You may not feel like it after being in the room for 10 hours, but you are, you can't be forced into reaching a decision, although you might feel you're stuck between a rock and a hard place. But and a lot of things, it's a pretty harsh environment. There is no, mediation is voluntary, so there is no, you can't be forced to attend, and there is no, what happens in mediation is confidential, so it can't be used against you in, if it doesn't settle, as a basis for costs, although there can be some subsequent things, it becomes a bit technical. If you're made if an offer's made, and it may be a basis for costs, but it's rare. So and people can't tell us what happened at mediation, so we can't take that into account when it comes to a tribunal hearing.
What happens in the case of last man standing?
The last man standing means that with I'll just give an example of a hearing I did, and the decision's probably going to be released tomorrow. I have concluded that there are 3 parties who have liability in that case, and that they're all joint and severally liable for the full amount. The apportionment, that I'm saying that one party is only responsible for 5%, one for 35%, and the other one for whatever, that 60 must be, I think. So if everything's fair and equal, one person will pay 5%, one will pay 35%, and the other one will pay 60%. However, if one of the parties doesn't pay their amount, the claimants can enforce the full amount against everyone. So the last man standing will be the person who the claimants think that they've got the best opportunity of getting the money from when an order is made. It only applies to an adjudicated outcome. It doesn't generally apply to a mediated outcome. Well, I know that the hearing I did, where we had all this expert evidence on designer and architectural responsibility, the reason why the designer wouldn't go to mediation and was adamant he was going to an adjudication hearing, I understand, was because he had designed 8 other houses for the same builder, so it just wasn't one claim. He would have paid to make that claim go away, and it may have been more cost effective for him, but he was aware that there might be 8 other claims following, because if the builder had done the same things on those, they'd also leak. So it was worth it for him to proceed to an adjudication hearing.
That is
the 5% person could still be left with a lot, because even though his contribution was small, the area in which he was responsible, that defect alone would have caused a complete reclad. But if for example, the only design thing could have been repaired by a targeted repair, it may be that the designer wouldn't be liable for the whole amount. So there are some parties who may only have partial liability because the responsibility they have just relates to a discrete area.
Are claims made against companies or against individuals within those companies?
Well, the companies are still operating. The claim is made against the company. Claims can be made against a director if the director was personally involved in doing the work, and sometimes an employee if they actually did the negligent work or supervised it directly. I think time's gone. I'll hang around a little bit over afternoon tea, so if you've got any other questions you want to ask me, I'm happy to answer them.
Thanks, Trish. Well, I think fantastic to kind of hear some of this, and I just think the getting an understanding of the legal basis of defences is probably quite important. So if anybody wants to go along and sit with a few homeowners and listen to that, I think it's probably quite valuable. I would be quite interested in seeing how many RFIs you get tomorrow if you join a council to a claim. That could be, yeah, unfortunately I kind of have to work with them for a while.
That's true.
Dean made a valid comment in my ear just before, and phone your insurance company.
Yeah, I meant to say that.
Yeah,
I should have said as soon as you get notice, phone your insurance company if you've got an insurer.
Right, so thanks very much, Trish, and I'm sure if there's anybody got any questions we can ask over afternoon tea. So.